Okay, so a very warm welcome to the 25th session in our, India Smart Protein Challenge 2021-2022. Radhika, you can share the screen introduction slide. Just welcoming all of you to this 25th session in our phase 4. And as some of you might know who are joining our series for the first time, this is the 25th installment in a long series of webinars and expert knowledge sharing sessions that we have done for ISPIC 2021. We are calling it the Inspiration Webinar Series because it's all about seeking inspiration from the mentors and expert speakers who share their insights on these sessions. We started the ISPIC 2021 challenge with 750 people, young students, professionals, entrepreneurs, professionals from different backgrounds and areas outside of food science, agriculture science, and life sciences and engineering disciplines. That is usually the kind of audience we have for the challenge. We were joined with multiple experts and mentors who took our teams. Now we have almost 20 teams, the top 23 teams in phase 4 of the challenge after a 4-month journey. So this has been an exciting journey for all our participants because they started out with a vague idea of what they might want to work in the plant-based, fermentation-derived and cultivated meat, eggs, and dairy space. But now they have kind of solidified their ideas after working on a detailed 20 to 25-page proposal in phase 3 and really thought through aspects of commercialization, aspects of food safety, environmental effect of their ideas and solutions, on aspects of building a scientific design and flowchart for the entire process, scale up and commercialization. And obviously, given the fact that these 3 technology areas are so technology led, there are a lot of IP considerations in the sector. So we hope that today's session on IP considerations for the smart protein companies really helps all the startups, entrepreneurs, and perhaps core team members, scientific members, and advisors of the smart protein ecosystem understand a little bit about these needs better, following which we'll have a Q&A towards the end. So Radhika, on to you. Maybe you can have the sponsor slide.
Thanks, Shardul. I'll just go over just setting some context and then maybe I can share the slide on the sponsors. Is that okay?
Absolutely.
Okay, thank you. Good evening, everyone. A very warm welcome to all the participants and teams to the second regulatory webinar of the India Smart Protein Innovation Challenge Inspirational Webinar Series. We have planned a series of regulatory webinars to equip you and give you an overview of the various legal considerations as you are forming your products and developing your go-to-market strategy. I am Radhika Ramesh, Policy Associate working at GFI India, and I will be your GFI host for this session. We also have Shardul Dabir, our Innovation Specialist, and Satvika Mahajan, our Senior Policy Specialist, who will be my co-hosts. Before we begin, I'd just like to go over a few guidelines for the engagement. You may utilize the Q&A button for questions. Okay, thank you so much, everyone, for joining in. Sorry for the technical issues. So I'll just give you a brief introduction. So thank you all for joining the second regulatory webinar of the India Smart Protein Innovation Challenge 2021's Inspirational Webinar Series. I am Radhika and I will be your GFI host for today. We also have Shardul Dabir and Satvika Mahajan, who will be my co-hosts for this webinar. So before we begin, I'd just like to go over a few guidelines for the engagement. You may utilize the Q&A button for questions to the speaker. Please feel free to use chat box to post your questions and please do restrict them to the topic discussed. Your questions will be taken up during the Q&A session. Just before you post your question, it would be helpful to just post an introduction to your name. You can also use the raise hand feature at the bottom of your computer screen if you want to post a question directly, and we will unmute you to ask your question. For the rest of the presentation, please ensure that your mics are muted. Great. So today's regulatory webinar is conducted by one of GFI India's Regulatory Advisory Council member. The Regulatory Advisory Council has been assembled by GFI India to provide focused regulatory advisory to the industry and to share inputs on a clear regulatory path to market with the regulators for the smart protein sector. It consists of legal and regulatory experts from India who have experience across different legal themes such as food laws, intellectual property rights, company laws, and other legal compliance requirements needed to operate in India. Today, we have Mr. Vikrant Rana, who is the managing partner of SS Rana and Company. SS Rana and Company was established in 1989 and is considered one of the leading IP and corporate law firms in India. SS Rana has several regional offices across India and represents several Indian and international companies. Mr. Vikrant is a seasoned IP lawyer and has been working in the law practice industry for about 20 years. He is skilled in negotiation, trademark infringement, patent law, IP strategy, and corporate law. Mr. Vikrant is also a registered IP facilitator with the Indian Patent Office to provide startups and companies with a range of services related to the protection and commercialization of their intellectual property rights. A very warm welcome to you, Vikrant, and thank you so much for being a part of the Inspiration webinar series.
Thank you so much for that kind introduction, Radhika. Well, it's always a pleasure to address young innovators. And first of all, I'd like to congratulate GFI and the participants who participated in this contest. And I'm sure, you've been shortlisted after a very drilling campaign. So congratulations for that. So like Radhika mentioned, so I'll be touching upon the various facets of IP, and especially for the startups. Radhika, could I share mine now, or?
Just before that, I'll just go over.
Sorry.
Yeah, no problem. So I think
you're on mute.
I would like to share some context about ISPIC first, and then maybe we can hand over to Vikrant. Shadu?
Yeah, thanks. Can we have the sponsor slide? Yeah, perfect. Thank you. So obviously this is all possible because, we've been supported as a non-profit in this non-profit initiative with few of our title sponsors, key sponsors, and our organizing partner, Capri Global, NICE, Alchem Foundation, and CI Eco at IIM Ahmedabad, respectively, but also a support of, supporting academic and research institutions across the country, NIFTM, BIRAC, CCAMP, CCMB, Sign Incubator at IIT Bombay, ABLE, IIT Madras Bio Incubator, and a plethora of VC accelerator and incubation firms across India who are focused on helping support startups and innovation and pioneering research within this ecosystem. So we are very glad to have them on board. And with that, I think we can get started with the session, Radhika.
Thank you. So before we get started, I'd just like to set some context about the webinar itself. So as you know, IP protection is very crucial because IP can be a unique selling proposition of the product or service in today's competitive and dynamic entrepreneurial landscape. It helps create a sustainable and defensible differentiator for a startup. IP rights are key economic assets in today's knowledge economy. That's why startups and SMEs need to build an IP strategy in the early stages of their development, and such an approach will enable them to leverage their IP assets for growth. So today's IP webinar will be focused on giving you an overview of the various different types of intellectual properties and the registration processes to secure protection. We will also cover IP considerations for startups, and lastly, provide an overview of the various IP-related benefits and schemes offered by the Government of India. So now I think I'll just hand it over to Mr. Vikrant to share his screen and begin the presentation.
Thank you so much, Radhika.
You should be able to share your screen now.
Yeah. Perfect. Thank you for setting the context, Radhika. Like she mentioned, IP is a very important commercial asset, and most of the times we see the innovators, not just the innovators, but even companies with good history, they're not looking at IP the way they should be looking at. And thankfully, there is a sea change in that aspect of considering IP to be a very good, important business tool. And this presentation would be to touch upon the various facets of IP and briefly on the registration process and why it is important. And we'll take it from there then. To start with, like Radhika mentioned about the importance. So IP plays a very, it has a very symbiotic relationship with business. Most of the time, the companies are building assets, and IP comes in to protect those assets. And it is only when you protect those assets, you're able to create a entry barrier for others in that domain, which would result in generation of value to the product, growth. So it's a cycle which comes into play once you are able to focus on building and protecting that asset itself. So that is where IP comes into play. We work on building and protecting by filing and registering those IP in the jurisdictions where we intend to do business. Coming to what would investors be looking at when they're investing in a company, in a startup, or a mid-sized company, they would be looking at the potential, the product or the company, what kind of potential that company has or the product has, the kind of business competitive advantage that product would have that they should be investing in, so that there are no other competitors in that domain, and they have a wide market share, a very sizable share because of the competitive advantage and the viability of the product itself. And all these points, if you look at, this is where IP comes into play, where IP, once registered, once protected, would indicate that it has a potential. There's a potential because it's a new innovation which has been recognized by the patent office. Once it is granted, you have a 20-year protection for a patent, 15-year for design, and that would create that entry barrier for any person coming in later. So that would give a VC that kind of a security that once they're investing in a company, that advantage is there, and that would also help in increasing the market size and share. And commercially viable, most of the patents would be, but not all. But yes, that would definitely indicate that there is something worth looking at if that patent or an IP is protected. We have seen that companies which have invested in IP assets, which have built portfolios of IPs, right from trademarks, patents, designs, copyright, they have definite a much higher likelihood of success in cases of having venture capitals funding them, lower probability of bankruptcy, and a higher probability of successful exit through an IPO. So these are, creates that kind of thing with the companies, that they are more likely to succeed than fail if they have really valued their IP and invested in IP at the right time. So that right time is crucial. And for a startup, it's more crucial, because for a startup, they're looking at different things, trying to balance everything. And at times they could miss out on protecting and even looking at IP as a business tool. So what mistakes startups normally do? Like I said, they're trying to balance too many hats, and it could lead to missing out on one of their more important rights, the business tool of IP. So the first one is the DIY approach. They try to do it themselves. That could create issues in the sense they may not be able to recognize that they are sitting on an IP. They may try to do it, and like a patent is a techno-legal document, and if they try to do it themselves, it may not come out the way it should have if done through a professional, and that could dilute or even take away the right which they could have got under a patent filing. So it's important, to a certain extent you can do that, but it's always advisable for your IP, like design and patent for sure, that you go to the right professional and not try to do this approach on your own. Second important thing would be the improper document foundation, and especially for a patent, creating those logbooks in the labs or the shop floor is important. Having those documents to prove at a later date, and also to have the evidence and the proper, the working of the patent itself. That would be useful if those documentation is maintained properly for patents, and even otherwise, which could be useful in case of trade secret issue, also in case of sharing of information without authority. So those documentation is important to have. Those logbooks should be maintained. Ignoring standard IP practices, again, like I said, it's because they try to do it themselves. It may be possible that they could have ignored the standard IP practices of filing first, where to file first, what to file first, filing a provisional or a complete. So those practices or the strategy could be, not done in a more professional manner, and that would also be from lack of an IP strategy. You probably as a startup, we have seen that IP is certainly not on the top of the list for a startup. They're looking at launching a product as soon as possible, and without checking on the confidentiality controls, without having a proper IP strategy drawn out. And it's quite understandable, because they are short-term funds, they're short-term people, and their go-to-market is more important for them than actually looking at other facets, and IP somehow takes a backseat. So we need to be sure that IP does not take a backseat, and how we can ensure could be to look at IP as a very important strategic advantages tool for them. So they should be looking at that and not underestimating the importance of IP in the whole business scenario. Not setting up communications would be within the team for confidentiality purposes also, but even otherwise, between the team and what has to be patented, what has to be filed as a design, and having a proper, as part of the IP strategy to figure out what has to be done to protect on a more holistic level, and which is really helping the business and not just filing for the filing's sake. Finally, the bottom line is that patent, if filed, should be it should be commercially viable, and you're able to get some revenue out of that. So that revenue stream should be visible within that IP strategy. I think failing to run a trademark and patent search, it appears to be a very small thing, but it is actually a very big thing for startups, not startups, for other companies also. We have seen that, for patents also, you could be redoing what's already done, or you could be actually doing something on the patent front and launching a product without conducting a search. It could be that it's already known in public domain, or it's already filed by somebody. If it is in public domain, then anyway you can't have a monopoly on that. And if it is filed by somebody, you could be infringing a third party's patent and could be ending up on the wrong side of law. So it's important to do that patent search at the right time when you're about to start working on a product, that this is the timeline, this is the product, and this is what we need to search, and to ensure that we're not kind of reinventing the wheel there. A trademark also, we have seen for many of our clients, including startups, and actually for a well-established company also, where they were launching a product, and just before 2 days before the launch, they got to know that the trademark is already taken. So we had to, luckily that trademark was registered but not being used. So we were fortunate enough to buy that trademark and have it assigned to the company, and the launch went ahead, without any issues. But if we were not able to buy that, we could be, obviously not able to use that mark, and could also be on the wrong side of law and paying some penalty and damages for using that kind of a trademark without permission and without conducting a search. And lastly, but most importantly, IP audit. We see that, IP audit, like I said, IP is not a priority somehow. So IP audit is also not a priority, but it's important to understand and probably take some professional help that, you have to conduct an IP audit, just like a financial audit, probably at least once a year, if not more, to understand that you could be sitting on IP, sitting on some valuable IP, but you would not have done enough to protect it. So you may have missed the bus, but if you do those audits on a regular basis, you could ensure that the next time around you are able to protect it, and that comes into play as a regular thing, which would be linked with the IP strategy itself. So we need to figure it out, that these are the common mistakes which actually go to the to the bottom, and which can affect the bottom line also. So one mistake could be a really big one, but still it's important that even if you have made it once, we try not to do that by using professionals in the field who can really help. But it should be a learning, and we should not be repeating that again. So it's important. I think this is very important for all startups to look at, that they don't do this. So coming to the IP, core IP, what is IP? So IP has, the different IPs are, copyright, patents, trademarks, designs, trade secrets, geographical indications, plant varieties. So I will be speaking on a few of them, not all, but a basic bird's eye view, and we'll be taking you through them. So what's a trademark? For a person on the street, when they go and buy a product, trademark is the first point of contact with your customer. He wouldn't know what patent has gone into it, what design could be equally important, but trademark and designs would be important to make that customer buy. That buying decision would be influenced by the trademark and by the design, the look and feel of the product. You go and buy an iPhone because of iPhone. You wouldn't know how many patents have really gone into it, what is the working or the functionality, but it is probably the aspirational thing because of the design or because of the trademark that it's coming from a particular company. So the main function of a trademark is to indicate where the product is coming from. So once we see iPhone, we know it's coming from the Apple company, or we see a Mercedes-Benz, so it signifies the quality of that product. What kind of quality would be, what to expect from that product, that comes through the trademark, the brand which is being used. Then the trademark also helps in creating a brand loyalty. You have a product, you are using a product which is of a certain quality, you like that quality, you would go back and ask for the same product using the same, the trademark. So that creates that brand loyalty, awareness, and that is why it is very important for a startup to, do that search and go for registering those trademarks. Trademark is a common law right. So even if it is not registered, but you have documentary evidence that you were the first one to use it, you would be the senior user and you would still be able to protect it and enforce it against people who are subsequent in time to your trademark. I think I've already talked about the clearance searches, but clearance is not only from the trademark database of the IPO, but you should also be checking the company names, that you're not coining a name or a trademark which is already used by a company as part of its name. You should be also checking if that domain name, the corresponding domain name is taken or not. Because we are living in this so connected world that once you launch a product, it is imperative that you also have an online presence. And for that, if you have a corresponding domain name, it'll be really helpful. So that search would be also including the domain name, the online presence also. And probably now for the social media handles also could be something which we could be looking at there. Then obviously right now we're looking at launching a product in India, but tomorrow it could be that we would be going worldwide. So probably it may be a good time to see that the trademark you're coining is not something which could mean something in a different language. If we're launching something in India, but the product name in Spanish could be something which is not culturally acceptable. So we need to keep that in mind if there is a certain market abroad. So keep that in mind when you're coining those trademarks in India. Coming to the timelines, timelines, it's much faster now. I mean, when I started practice in '96, which is almost 25 years now, it used to take around 10 years to take a trademark, to get a trademark registered. So by the time many businesses would have folded up and the trademark was still not granted. Thankfully, things have changed now. You file a trademark and it is examined within a month now. And if there is no objection, it is accepted. You get a trademark granted in 5 months. If it's a very strong, good trademark, so 5 months you have your trademark, and you can really plan it well so that by the time you really launch your product, you're able to get your mark registered before that. So that is very much possible in India now. Even though we are filing almost 350,000 applications annually, but the trademark registry has done a very good job at getting those examined at a very quick pace. So that is about trademarks. This was just an example of one of the trademarks which have been recently filed protein for use as a meat substitute. So we are already seeing a lot of filings coming from companies in this domain, a lot of trademarks being taken. And I think it's a good idea to start looking at a trademark at least 4 or 5 months before you're launching a product to see they're available and you're able to get them protected before you launch the product itself. Coming to a more relevant topic in the sense of the functionality, where I think most of you are working on the innovation. So the innovations are protected under patents. So that is an exclusive ownership right granted to the owner of an invention. And the invention is defined as a new product or process involving an inventive step and capable of industrial production. So that trinity has to be maintained, that you are able to have a product with inventive step and capable of industrial product application and utility. And the exclusivity would include and imply that the patent holder can prevent others from making, using, or manufacturing the invention without the consent. So it's a right for 20 years. You have monopoly, you have exclusive rights, and nobody can use that for those 20 years. So that's a big entry barrier. By the time it expires, you would have a clear run in the market. So it's important to figure out that you have a patentable invention and therefore go for a patent as soon as possible. Stages for an innovator, it's important. Like I said, clearance is very important for patent, trademark, design, or whatever IP you're filing. It's important to have it cleared, and we should not be reinventing the wheel there. And that prior art search is very crucial that we do that. And the prior art search is not limited to India, because the novelty which the patent office would look at is on a worldwide scale. So anything published anywhere in the world or a patent granted anywhere in the world, you cannot file a patent for that in India. That will not be accepted because that would not be novel. So that's important that that search is conducted. So we know that nothing similar is there in that particular domain. But we have to keep in mind also, like in India, patent application is not published for 18 months. So there could be a black hole of that period where the applications are filed, but yet not published. So your search would not be 100% accurate, up-to-date search. So we have to keep in mind there would be certain innovations, which could be filed, but yet not reflected in the search. So that's important to keep on the search side. Again, there's a provisional or a complete specification, which is acceptable under the Indian patent laws. So a provisional is where we know the outline, we know what has to be filed, but we haven't really gone in too much detail of preparing the claims, preparing the detailed application. There's still more experiments, more research into it, but the basic outline is there. So you could, just to put your foot, you could file a provisional application. And you have 12 months to complete that filing by filing a complete application. That period is good enough to really complete that. And I'll take you to the next slide where the filing outside India is also 12 months. So we have to keep in mind that after provisional, we need to do the complete filing and also the filing outside India within that 12-month period from the first filing, which is the provisional in this case. In a normal prosecution, the application, like I said, is not published for 18 months. And after 18 months, when it's published, you have to file a request for examination. It is not examined suo motu by the patent office. You have to file a request, and that can be done within 48 months of the first filing date. So if you're filing first in India, then within 48 months, you can and you have to file the request for examination. Otherwise, it will not be examined at all. Once examined, you have to submit your response to the patent office. And if the patent office is satisfied, they would accept it, or they would list it for a hearing. And if it is accepted, then it would be granted and would be valid for a period of 20 years from the date of initial filing. This is on the the flow chart regarding the filing. So we have mentioned about the provisional and the complete, and you need to go. And if we have to go abroad, international filings, then we have to do that within 12 months. So there are two ways to do that. One is the Paris Convention, and second is the PCT. So the Paris Convention, I'm especially mentioning this because at times you feel, as innovators or startups, they feel that, we are doing this probably only for India. That may be true, but you might be missing out on a larger market by not filing abroad or not considering to file abroad. The whole purpose of the PCT is to give you that kind of extra timeline to consider whether it would be a commercially viable project in India and outside India. So what Paris Convention does is it gives you 12 months to file that. The only drawback here would be if I need to file in, say, Japan or China, I need to have it translated within that 12-month period. So that would add to my cost. Then I have to look for local agents in each of the countries, which would be, if it's a last minute thing, it would be, again, a difficult and inexpensive issue there. And you have to pay official fees in each country. That means you have to transfer it to all associates separately, which could also add to the the cost, the banking charges, and the whatever fee required for transferring those funds. So to mitigate that, these drawbacks, unless obviously Paris is good if you're looking at a couple of countries, but if you're looking at more countries, then PCT is a more relevant way to take it abroad, or at least to take it to consider to take it abroad, where you can file the PCT at the 12-month deadline. So you are able to secure that date internationally for all the countries by filing that PCT application. So you have paid that amount, a basic fee has been paid with all the countries checkbox ticked, and you are securing yourself getting that filing date for all those countries. So that is, I think, very crucial. Sometimes we miss out, and sometimes we feel, it's not that good an invention to go out. But if we are able to invest that kind of resources for securing that PCT application date, I think then that gives us additional almost 18 months, that is 1.5 years from the 12-month date. So that is 2.5 years from the filing date, that is 30 months, to actually go into each country. What Paris did, we had to go at the 12-month period, but now we can go into each country at the 30th month, or probably the 31st month in some countries. So that gives me a lot of time to really plan out that, is it commercially viable? Is it actually patentable? It's possible that within that 12-month period, I can get an idea from the ISA, the International Search Report, or from any other country that this is not a patentable invention, or this is really actually a very good patentable invention, which could encourage me to keep going on the PCT phase and file national applications. So if we have that okay, this is maybe a good invention, and we have the resources, we would definitely recommend to file a PCT to get that filing date to secure that. I think I'll just go back to one slide on the stages of patent filing also, and this one also. So two things I would mention. One is there's a pre-grant opposition. Once a patent application is published, there's a provision for filing a pre-grant opposition. And there is also a provision for a post-grant opposition within 1 year of the grant of the patent application. So these are two issues. Why I'm saying that? It could be a good idea to keep a tab on what patents are being filed by people in the same industry, by competitors. And also if something which is of generic nature, which is already known, could be blocked from being granted patents. That is one thing. Secondly, I wanted to mention here was that publication, like I said, it is not published until 18 months, that is there, but there's also provision for an expedited publication. So if you want to really expedite the whole process, the whole patent prosecution process, you could actually file a request for an expedited publication. So it is examined, it's published very fast, within a month or so, and then it could be examined. And for startups, they have really made those rules to really expedite for the startups, where these are granted and within 7 to 8 months. We've had patents granted for startups in less than 7 months. So I think it's a misnomer. It's a somehow we need to dispel this, that getting a grant in India is a very tedious and a cumbersome process. It is not now. It's much easier. And the patents are granted much, especially to the startups and the criteria they have laid out in a much more timely manner, where you can actually commercialize that patent within its lifetime. So coming to, these are some examples we took out where protein-based meat patent applications have been filed. So if you look at the last one, this is actually filed in 2007. So that's almost 15 years ago. Somebody had filed for meat substitute food product and preparation method thereof, Sigma Alimentos, which is a granted patent in EU. Similarly, in US, you have meat-like food products by Beyond Meat. Then China, Jiangnan University, they filed for plant protein meat performing process and plant protein meat product. Japan, simulated meat food product and method for producing simulated meat product. So I mean, so we see from the patent records, these have been filed for a long time now. It's good. I mean, GFI and the innovators are looking at protecting that IP and innovating and protecting in India. And probably this is the right time to do that and really get into that zone of filing and protecting. And these are some examples, which are Indian examples. I talked about 2007 in worldwide, but we see that there are a number of similar patents being filed and granted in India also. Like 2007, here again, we see Sulai LLC, they filed for use of low pH to modify the texture of structured plant protein products. Then Nestec food compositions having a realistic meat-like appearance, feel and texture. Then Nestle vegetable-based minced meat alternative, Impossible Foods ground meat replicas. So these are a number of patents. If we look, companies are already coming in this domain, and this could be just the right time to get into this too. Yeah, this is plant-based meat worldwide patent application. So this is just to give you an idea what kind of numbers we are looking at. This is obviously with a certain key string, so these numbers could vary if the string changes. But this is just to have an idea that this started from 2013. We have been looking at these kind of patents being filed on a worldwide basis, and which are now certainly coming up, growing in the last couple of years. Number of patent applications granted in different countries. So we see that China, there are almost 150 patent applications granted in this domain already, and followed by Japan, Europe, USA, Germany, France, Great Britain, Korea, Canada, Mexico, Australia, Brazil, and then we have India. So India also, we have around 29, which appear to have been granted in this particular domain. So a lot of potential, a lot of filings, and which is certainly, it looks like it's on the rise. Yes. So I think we've done with patents there. So coming to designs, like I said earlier, design is one of the factors which really comes into play when a person is buying a product. You are buying a product for the look and feel of the product and maybe functionality, but yes, that look and feel plays a very important role in a consumer's decision to purchase a product. And that is where design comes into play. It's one of the most underrated, underutilized right in India. If I mention, the number of trademarks being filed being 350,000 trademarks in a year, we have less than 20,000 designs being filed in a year. So there's a big potential. There could be possibilities where the product you have made may not have a patentable functionality there, but it could certainly have a design element which could be looked at to protect it. So you have to look at IP as a more holistic way, and not too specific that, okay, I have to go and get a patent. Whatever is the right right, you need to look at that and protect that or the whole gambit of different rights. So designs are basically, in a very layman term, is the look and feel of the product. Anything to do with the shape, the configuration, the pattern, composition of lines or colors, the ornament, the look, what really appeals to the eye is design. And that is what the act says, that anything which appeals can be protected if it's applied to an article by an industrial process or means. And it would not include any functionality. Like I said, functionality would come under patent. So there could be possibility that the same product could have a patent element and a design element. A patent may be granted or not granted, and design could still be granted, if it's a real novel thing. So you have to look at that product, that filing, and preferably file them on the same day so that the novelty is not destroyed. Just like patents, we have a worldwide novelty for design also. That implies that if that design has been utilized or used or granted or published anywhere in the world, then it cannot be filed. It would be treated as the novelty has been destroyed, and you cannot have a right on that. And we have seen that people destroy the novelty of their own product by launching it on the website, or publishing it, or talking about it. And the media is talking about it. I mean, yesterday we had worked with somebody, and their son came up with the special mask for the COVID. And it was really unfortunate. I saw that in the news, and I called them up that this was such a new innovation, and they had gone to the media first before talking to the patent lawyers. So that, I mean, you kind of destroyed the novelty yourself. You've really hurt yourself by doing that. So you have to ensure, just like for patent, that you do talk to a patent professional, see if there is a right which could be claimed, and file that before you make it public. And it's not necessary at all that you have to wait for the patent or design to be granted to make it public. The day you file it, the next day it can be made public, because you have secured that date of filing for patent or design. So keep that in mind. I think that's the biggest thing. The takeaway for today would be that the novelty has to be considered, and it has to be considered on a worldwide basis, and you ensure that you don't destroy it yourself. Okay, so like I said, it's not new or original, will not be granted. It is already disclosed, or it is not different from the known designs, then the design will not be granted. Normally you would have thought, why a design is being told to us. We are into the food business, so why us? So these are some of the designs we found are filed for food-related goods by food-related companies. Kraft, Grove, Frito-Lay, Mars. They have filed the shape of snack they've protected as design, right? So we have to keep in mind that if there's a new shape, there's a new shape or configuration of a product, then it could definitely be protected as a design. So you could look at that particular thing. Obviously, you have to keep in mind the novelty criteria, that it is there, it's not destroyed by you, or it's already in public domain or not. And basis that, you could file application within India. And similar to patent, you have an opportunity of a 6-month window to take the design outside India. So if you have you have filed a design application in India, in other member countries, you can file that within 6 months and claim the priority of the Indian filing date. So suppose you have launched, you filed the product design on 1st of January, and you file in EU on 30th of June, and somebody has launched a similar design on the 5th of January, you would be still considered to be senior, because you're claiming priority from the 1st of January. So keep that in mind, that 6-month window should be calendared, and you should look at the commercial viability of the project, of the product, and if there is a target market, and look at protecting that. And especially Europe, like I said, I mean, it's a whole the whole continent, I mean, at least the EU is covered under one filing. So you save that, and one filing would be good enough to do that. Coming to copyright now, Copyright again is not dependent on registration. So even if you have not registered it, you can protect that. And it's like, you're writing a manual for your product. That manual, the way you've written, it's the expression of that writing that is protected. It's just not the idea itself, but the how you have expressed that would be protected. And for a literary product, for a musical product, for a video, all those could be protected under copyright. The term is 60 years after the death of the author, so it's a very long term. And what we have to keep in mind as innovators, as startups, is that when author of the work is an employee and the work is made in the course of employment, the author is not the owner. So the employee would be author because he has created that work. He has the paternal moral rights there, but he will not be the owner of the copyright. So, and it's also important for other, your vendors and other people who are doing work for you, who are creating something for you, that you have proper agreement with them that anything which they create, because it's part of the contractual obligation, that you will have right on that IP, including copyright, design, patent on that particular IP. What is not protected under copyright? Facts, ideas, systems, concepts, methods of operation, titles, discoveries, and principles, they will not be covered under copyright. One important thing where we have to keep in mind is design. If you don't, like I said, if you don't file a design and you make it public, the novelty is destroyed and it goes into public domain. So, but there's one exception, and this is very particular to India, where a design has been launched, the novelty has been destroyed as per the act because it's already in public knowledge. But if it is less than 50 designs, you can still protect under copyright law. So that you have to keep in mind. If there's a very exclusive product, I mean, we have it for fashion designers where they have less than 50 products. You can very well use this, even if the product has been launched, but is in public domain, but not filed as a design, you can still protect it. So this was just a passing remark on that. Coming to trade secrets, again, this is, we don't have a statute on trade secrets in India. But again, we have very good examples of where products have been kept as trade secrets for a number of years. Like I think the Coca-Cola example is one of the big ones. The KFC recipe, that's an example of, again, a trade secret which is not being shared out. In fact, it's very crucial to understand when to decide what to file. It could be that you may be encouraged to file a patent which could be protected under trade secrets. We had somebody come from Kannauj. Kannauj is the capital of perfumes in India. And he said, okay, this is in my, it's being passed over generations. It's not in public domain. So I've been told to file a patent for it, because you will get a certain valuation. I said, I mean, the valuation would be there, but then you are making it public. The whole idea of a patent is that you have to share it with the government so that after 20 years, it comes into public domain. So if it is something which can be passed on to the next generation, or it can be kept as a trade secret, then it may be better to keep it as a trade secret. The only issue is that if that trade secret goes out for whatever reason, you can obviously sue the person who makes it public for whatever damages you can. But once it is out, then it is out. Then you cannot protect it in any manner. You can only claim damages, but not protect it. So that call has to be there. You have to be judicious whether it can be filed as a trade secret. Can you keep it as a trade secret? Or you go and file a patent for a limited 20-year period. This is only to show that one product could have number of rights, so do keep that in mind. Don't just go be gung-ho on patents. Okay, we are innovators, so we are only looking at patents. We have seen that many in the domain look at only for that. You have to look at a market differentiator. It could be any right, and like I said, trademark, obviously you have to have that the face to the public, and the design is I think the underutilized right, which you should be looking at if that is a possibility in that domain. Startups, this is just to indicate again, what they should be looking at. Filing early is important. You file at the right time. Don't even a basic idea, file a provisional, get your foot in the door, get that filing date. That's important. Additional filing, again, you need to review. Like I said, IP audit has to be there. You need to see what has been added to that innovation. Can we file a patent of addition, or a new patent has to be filed? So that periodic review is required, surely. then prioritize not only for filing in India, which class has to be filed, what patent has to be filed, which domain has to be covered, which country has to be covered. PCT has to be filed or not. So that prioritizing has to come into play, and probably with more professional help. That okay, this is what we are looking at, this is what we are targeting, and this is how it has to be prioritized, which will work with the IP strategy which we had discussed earlier. And again, trade secrets, very important, could be within the organization. That's why important to keep logs, important to keep, mark emails, mark communication with your vendors, VCs, and employees as confidential. So it is not in public domain, not considered to be in public domain. So that is captured properly, that this is not information which has to be shared, but is confidential and privileged for the eyes only. Worth of the invention, yes, it would come in once we have the life cycle complete for a patent grant, for commercialization, and regularly conduct market and business analysis and surveys there to see how how to expand and how to finally, I think IP is there to help the bottom line. If we the whole purpose is to increase revenues, to find revenue sources, and then expand onto that. The first slide, like, it would stimulate growth, and which would help in building more assets and helping in protecting those assets further. Just a brief touch on the legal agreements. I think it's very important. Many of you would be more experienced, many of you may not be, but it's important to have those agreements. We have seen so many innovators come and say that we had oral agreements, we had discussed with the vendor, okay, do that, or we had shown it to the VC, we discussed, and tomorrow it was launched, they did this and they did that. So it's important, even with your close friends, even with your probably even family members who are investing or looking at it as a commercial thing, we should have agreements. There is nothing wrong. I mean, it'll be everything wrong if you don't have those agreements. So I would recommend that it's part of the basic SOP in an organization to have proper agreements. And these are three-pronged, which is important. One is the employee within the firm, within the company. You have to have proper agreements so that all IP which is generated by them is owned by the firm or the company which has really invested in the employee and the resources to come up with that invention. Second is the vendors. We outsource a lot of things which could not be done in a house. So we have to have the proper NDAs, proper terms with the vendors that whatever is being discussed is confidential, is not to be shared, and not to be made for somebody else, or to be made public at all without written consent. So vendors would be there, and then obviously the investors, the venture capitalists or the other investors. You may be very kicked that somebody has shown interest, or they're looking at doing that investing, but you need to be careful that you do have the proper NDAs, proper agreements, proper terms in the agreements that would safeguard the rights and ownership for the startup. So that's crucial. We at times get carried away that somebody big is calling us, or somebody is really interested in this, and we may miss out on those small details which can be really backfire in the long run. So please do keep that in mind too. Some of the key clauses, obviously I'll not go into detail, but confidential information has to be defined. I would also suggest that any communication outside the company firm should be marked confidential or privileged, if the case may be. So it is there that this is confidential and not for public knowledge. Permitted purpose for using the invention could be specified. And for certain recipients, like even the VCs or the vendors, there should be a request for a back-to-back agreement. If they already have engagement agreements within their own setup, that is good. But if they don't have, then a back-to-back agreement should be there with the employees of the vendors or other people who may have access to that information. The invention to be disclosed only on need-to-know basis within the organizations outside our organization. They have to be obligated to exercise due care to maintain confidentiality, and must be obligated to return the confidential information if provided to them in a tangible format, or to delete whatever information they have in a soft format. And the confidentiality has to be maintained in perpetuity. It should not be coterminous with the agreement. If a proper agreement is there, then for a vendor to make that, and the agreement is only for a year or so, but the confidential information should be in perpetuity. Obviously, if that product has already been launched in the market, then if it no longer would be confidential. But otherwise, there could be certain products which are not launched for whatever reason. So they should be, clause should be there that this would be in perpetuity, and they should not be free to use or market those products for their own benefit. And it should not be contingent on the factor that the deal was not finalized. Obviously, it should not be. The whole idea is that it is only for discussing the deal. If it doesn't work out, then we alone have the right on that. And employees should not be claiming ownership, and they can be acknowledged as inventor. They could be named in the application, not as a co-inventor, because we have seen that sometimes not as a co-applicant. They can very well be marked as inventors, but there could be issues unless there's an agreement that they are inventors and they would also have a right on the patent. Then you could have them, but otherwise it's better to have them as inventors alone. You could have a royalty sharing basis which could be independent of the ownership of the patent. I could own the patent, and I could be that you are an inventor and employee. I could say that if whatever revenue is generated, you would have a certain percentage, but it's better not to have them as applicants to avoid any issue at a later date, because you wouldn't be able to sell or do anything without their concurrence. So we have seen that where two people came together, did that, and finally it was a very good patent, and they missed out because there was some miscommunication, some issues, and they couldn't see eye to eye, and the whole patent went to waste, a total waste of the patent which they had done together. Lastly, the agreement has to be a work for hire. Even if you're engaging a vendor, you have to mention that the work, if they do, if you give something to a vendor, there could be a possibility they may add on to something to make it better. So those improvements, if they are doing, that should be part of the contract. Of contractual ownership has to be with the firm itself and not with the vendor. So that should be included in the agreement itself. These are some licenses. I think most of you would be aware. FSSAI is periodic, legal metrology is one time, shops and establishment is one time, health trade license is periodic, and startup is one time, and MSME is one time. I'll come very fast. I think Radhika is there, so I'll just quickly sum it up. On the benefits of startup, I think it's very crucial. It's not just the financial benefits here, but the expedited which the government has done, especially for the startup. We should be looking at getting those benefits to have the patents granted in say 7 months. So if a startup is recognized by DIPP, you have the benefit of a lower fee. For example, for patents, it's almost 80% reduction. 8,000 fee is the normal fee for a company, which a startup pays only 1,600 rupees for filing a patent application. So just on the background, initially there were a lot of issues, especially 3 core issues with the patent office. One was this long delay of getting a patent granted, almost 15-20 years for a patent to be granted. Second was the official fee was high. Third was the patent lawyers were expensive. It was not within everybody's reach to do that. To actually reach out to a patent professional to help the guidance for filing the patent application. So the Startup India actually took care of these 3 drawbacks, where they reduced the official fees for the startups. They got more patent examiners. They've really got the examination process so streamlined now. You have, like I said, patent granted in 7 months for startups. And they have impaneled number of patent professionals, and these patent professionals, the name of these patent professionals is on the IPO website. So you can actually reach out to any of these patent professionals for advice on IP matters, for filing patent applications in India, and they would help you, and they would be paid by the government. So you don't even have to pay the patent lawyers for filing of the patent application. So that third issue of the fee of the patent lawyer being exorbitant was taken care by the patent office, now paying the fee for the lawyer. the fourth issue was of not finding the right person. So now, because the list is on the website, it's easy to go to the right person. So the fourth issue was that people would go to non-patent professionals, and the patents were messed up because, being a techno-legal document, it was not drafted the way it should have been drafted, and rights were lost in that sense. So by going to the right, by putting this list, the government has ensured that you go to the right persons who have the competence to help you in filing those patent applications. So SIPP is a wonderful initiative which should be utilized by the innovators, by the startups, to get the benefit of fee reduction, and also for benefit of getting the professionals where the government of India bears the cost for them. Then there are a number of other initiatives, like MSME ministry, they have these reimbursements for patents in India. Then they also do it for foreign patents, trademarks, GI registration, then assistance for setting up IP facilitation center of up to 1 crore for a period of 5 years. Then a number of initiatives which you could take a look at the MSME website and see if those are relevant, especially if you're looking at filing a patent outside India. That would be really beneficial. Then there is this PRISM, promoting innovations in individual startups and MSMEs. Again, this is one of the schemes for supporting up to 50 lakh rupees, limited to 50% of the total project cost. And this is provided for scaling up technology-based innovations, including patenting, design, trademark, technology transfer, and the target audience being individual startups and MSMEs. Then BIRAC, I think most of you would be aware, they have benefits where they are looking at patenting and technology transfer for harnessing innovations. And they offer IP and technology management services to startups, SMEs, and academia. And this is for all the grantees funded by BIRAC. It offers reimbursement for expenses towards different IP-related services. So these are some of the initiatives where you could look at and see how they can fit into your IP strategy and take benefit from these. I think I've covered most of the things I wanted to, but a bird's eye view, and I'll be happy to take questions after this. Thank you so much.
Thank you so much for that really insightful presentation. I think you covered everything these are really complex topics, and I think it was really helpful for the participants. We have a bunch of questions as well. But before we just conclude the presentation, maybe Shardul, you'd like to take over?
Yeah, no, thank you so much, Vikrant. I think this was genuinely helpful, as you can see from the number of encouraging comments we're getting and the questions we've had. I think the topics you covered are usually the kind of questions that people have around this theme and topic. So we're really glad to have you with us. With that, I wanted to check. Okay, so thank you so much once again, Vikrant, for joining us today and for the standing resource, which would be helpful for the startup and entrepreneurs and innovators alike in our ecosystem, and very, very relevant points to food industry specific startups. And I'm sure this information is going to be quite helpful for the Q&A section, which is going to be a closed door section. We'll stop the recording now, and we hope that our attendees join us in our next session as well. Thank you so much.
Thank you.